Hi, my name is David P. Shapiro. I am a San Diego-based criminal lawyer, and I'm the owner and managing partner of the law office of David P. Shapiro, based out of San Diego, California. And today I want to discuss with you some things about people who are charged with assault with a deadly weapon. A couple of things about assault with a deadly weapon. It can be charged as a felony or as a misdemeanor. There are a lot of offenses in California that can be charged as felonies or misdemeanors, and they are known as wobblers. The difference between a felony and misdemeanor are more extreme than others, and assault with a deadly weapon are one of them. And what I mean by that is this. If it charges a misdemeanor, well, it's a misdemeanor, and you could face up to 1 year in jail if you're convicted. If you're charged with assault with a deadly weapon as a felony, not only is it a felony, it could ultimately be reduced to a misdemeanor in the future, but it is a strike felony. It is a serious felony with increased penalties for future offenses as part of California's 3 strikes law. So the chips are really all in the middle of the table here when you're charged with a felony, because not only do you want to avoid a strike, you want to avoid a felony, if not a criminal conviction altogether. And a lot of times what we'll see is, someone's assault with a deadly weapon, someone has, whether it's a pipe or a tire iron or a knife, a gun, whatever the case may be. But a lot of times what we see is there may be injuries, there may not be injuries. That's really not the telling tale. What's important is if you're under investigation for assault, particularly assault with a deadly weapon, and if you're contacted by law enforcement, you have to understand your rights, and you have to exert those rights and say, hey, listen, I'm under no obligation to speak to anybody about this other than an attorney, and utilize your rights that you have, because so often people will come to our office after they've already spoken to the police. And the police will use these interrogation tactics, which there's nothing wrong with them. They're actually pretty effective, where they'll say, hey, we have you on video hitting this guy 6 times with a baseball bat. There may not be a video. They certainly may not have him hitting you 6 times with a baseball bat. But what do people say? No, I only hit him twice. What have you just done? You've admitted to assault with a deadly weapon 2 times, or at least certainly 1 incident of it. So, no real different than most other crimes. When you're under investigation, politely decline to speak to law enforcement or anyone for that matter without your attorney. Reach out, contact a quality, locally experienced criminal defense firm who could go over your rights with you, go over your options moving forward, and give you enough information where you can make the choice to hire the best locally experienced criminal defense firm that you believe is in your best interest. If you have any additional questions about assault with a deadly weapon, particularly if you or a loved one are charged with that, feel free to give our firm a call. Again, my name is David Shapiro. My firm helps good people regain control of their future when charged with a crime, particularly in San Diego. We can be reached at 619-295-3555.